Brittany Hall, and I'm an attorney with Cape Fear Family Law. I'm going to talk to you today about what we call post-separation support. So you might be wondering, what exactly is post-separation support? Well, post-separation support is sort of a temporary form of alimony. You can find post-separation support in the North Carolina General Statutes, Chapter 50-16. Whose spouse is actually dependent on them for money, for financial reasons, for maintenance, for any type of support. A dependent spouse is actually the spouse who is financially dependent on their supporting spouse. So once the court determines if there is a supporting spouse and a dependent spouse, then the court can determine if it can award post-separation support. The court determines if someone will have to pay post-separation support by looking at their finances. So basically, both spouses will fill out a form. We call it a financial affidavit, but really what it is just a budget form. And you put on there all of your income, and then you put on there all of your expenses. And the court reviews that. And at the end of the day, if the supporting spouse has a surplus at the end of the month, based on what he or she makes and what he or she has to spend. And if the dependent spouse has a negative at the end of the month and is in need of more money to pay for their reasonable expenses, then the court can order post-separation support. So what it really boils down to is, does the dependent spouse need the money, and does the supporting spouse have the ability to pay it? If the supporting spouse just does not have the ability to pay, then the court cannot order post-separation support. Another thing to keep in mind is that even if the supporting spouse does not have the ability to pay based on what we see on their financial affidavit, the court can still order them to pay if they have the ability to earn more income than the dependent spouse in the long run. So if they have more of an education, or they have the ability to go and get a better job than the dependent spouse, or if they have assets that they can liquidate, then the court can order them to pay even if it puts them in a deficit. So that's just something you might want to think about. It's not always the husband that pays post-separation support. It could certainly be the wife if she is determined to be the supporting spouse of the marriage. What you need to do to get post-separation support is to file a claim with the court. So you would do that by first hiring an attorney and going over all of your financial assets with that attorney. At that time, if the attorney determines that you are entitled to post-separation support, then you would file a claim, which we call a complaint, for post-separation support and for alimony. And then the court sets you a court date, and you simply go to court and you ask for post-separation support after you've submitted your financial affidavit. If you don't have an attorney and you want to file for post-separation support, you still need to file a verified complaint. This has to be a notarized, verified complaint, and you have to file it with the clerk of court's office. It costs $150 to file, and then you have to serve it on your spouse, and that costs $30 with the New Hanover County Sheriff's Office. In your complaint, you have to allege certain things by law. And you have to first allege that you are a dependent spouse and that you are in need of financial support from your spouse. You have to allege that your financial means are not adequate to meet your reasonable needs. You have to allege that your spouse has the ability to pay you post-separation support. You also have to file, along with the verification, the financial affidavit. That's the form that we talked about. That's basically the budget form. That also has to be notarized, and you have to file that with your complaint too, so that the court can review it. Tax returns, W-2s, pay stubs, anything that you have that would verify your income. You can also get your employer to do an employer certification of wages, which is just a notarized affidavit saying what you make. but you would definitely want to show some type of firm proof like a pay stub or a tax return. You would also want to show what your deductions are. So if you get a pay stub and that has deductions such as for health insurance or taxes, then you would want to show the court what those are. This will allow the court to see what your net income is after taxes each month. Then you're going to want to show the court proof of what your expenses are. So you can bring in bills, you can bring in credit cards, you can bring in receipts for things that you pay for on a monthly basis. If you are paying child support, you're going to want to show the court that you're paying that. If there's an order, anything to show what your income or your expenses are, you're definitely going to want to bring documentation and evidence of that to show the judge. Another important piece to the puzzle that we call post-separation support is that the law allows for a dependent spouse to maintain his or her accustomed standard of living during the marriage. So what does that mean, their accustomed standard of living? Well, it basically means that while you were married, if you were used to being able to spend a certain amount of money on clothes every month, or if you were used to going on extravagant vacations, not being in debt, any of those things that you were used to throughout the marriage, then the court can consider that and they will try to make you at the same standard of living as you were when you were married. So how do you show all of this information to the court that you need the judge to see to award you post-separation support? Well, if you have an attorney, that attorney will really take care of that for you. They'll make sure that they know how to properly enter it into evidence. You will still have to testify, but they will make sure that they help you through that process. If you don't have an attorney, then you're going to want to need to bring these documents to court, and you need to bring at least 3 or 4 copies of each document, because you're going to have to provide a copy to your spouse and a copy to the judge. And you're still going to have to testify about each document, and then you're going to want to ask the court to enter them into evidence. Marital misconduct can matter in post-separation support. So what is marital misconduct? Well, if you watch the video that Janet did on divorce from bed and board, she went into detail about what marital misconduct was. So you can refer back to that, but basically it could be a number of things. It could be adultery, it could be drinking excessively, any type of misconduct that a spouse had during the marriage. So back to how we could use this for post-separation support, and does it really matter? Well, only the supporting spouse can first bring up marital misconduct in a trial against the dependent spouse. If the supporting spouse brings evidence in about the dependent spouse's marital misconduct, at that point the dependent spouse can defend themselves and use evidence of the supporting spouse's marital misconduct. Marital misconduct on the part of the dependent spouse is not necessarily a bar to post-separation support. So even if you've had misconduct, even if you've committed adultery or some other type of misconduct, you could still get post-separation support. It's up to the court and it's in the judge's discretion. You also can get attorney's fees if you're asking for post-separation support. The dependent spouse is the only party that can ask for attorney fees. And again, that's another thing that's in the judge's discretion. They'll review and see if the dependent spouse is able to pay their own attorney fees. Many times they're not, which is why they're asking for post-separation support in the first place, and they may get awarded attorney fees. If they do, then the supporting spouse would have to pay their attorney fees. Post-separation support can be paid in many different ways. It can be paid in a single lump sum, but more frequently it's paid in monthly payments to the dependent spouse. Now, the supporting spouse can pay directly to the dependent spouse each month, or it can actually be withheld from their wages. So what that means is it would come directly out of their check and then deposited into an account for the dependent spouse. If your spouse doesn't have any income, but they do have some property that's worth money, then potentially the judge could order that they liquidate assets in order to pay their post-separation support. If the judge doesn't order them to liquidate the asset, they can also order them to transfer the title of the property to the dependent spouse. If you receive post-separation support, then you do have to claim it as income on your tax returns, and you do have to pay taxes on it. So that's something that you really want to keep in mind as you're receiving it, if you receive it in a monthly, a periodic payment, because you're going to have to pay taxes on it. So you might want to set a little bit aside to make sure that you have enough to pay the taxes on it at the end of the year. Now, if you're the one that's paying the post-separation support to your spouse, you actually get to claim your payments as a deduction on your taxes. The amount of post-separation support that you'll get is different in every case. We really don't have a way of answering how much you're going to get because it's totally in the discretion of the judge. There's no special calculation like there is with child support that is sure to tell you exactly what the judge is going to do. So the judge is going to look at your financial affidavit or your budget form. They're going to look at your spouse's financial affidavit, and they're going to determine what you need to survive and to maintain your standard of living during the marriage. And they're going to look at how much your spouse can actually pay. And that's going to determine what you're going to get in post-separation support. There are some counties in North Carolina that the courts have started to use their own calculation for post-separation support. Orange County is an example of that. Here in New Hanover County, we don't have a specific calculation that the judges are using right now. It's really in the discretion of the judge. But there are some places in North Carolina that do use a calculation. You can get post-separation support in a domestic violence action technically, but practically that doesn't really happen. Here in this county in North Carolina, the court system is really just going to tell you to go file that in family court. It's important to have an attorney help you to get your post-separation support because these are complicated legal issues. And it's hard for a layperson who hasn't been to law school or had the training to know how to go about getting what you're legally entitled to. And the most important part is you only get one shot at getting your post-separation support. So you really want to make sure that you get it right the first time. And if you're the supporting spouse and you're going to have to pay post-separation support, you also need an attorney to help make sure that your rights are protected and that you're not paying too much post-separation support or that you're not paying when you shouldn't be paying. So on either side of the coin, you're going to want an attorney to help you with this. Post-separation support does not necessarily determine alimony. Post-separation support by nature is what we call non-prejudicial, which means that in the long run, when you go and try to ask the court for alimony, they're not going to use it against you. Whether you paid post-separation support or whether you received a certain amount and you're asking for more alimony, they're not going to use it against you. It's a temporary order. The order cannot be appealed because you have alimony pending. Alimony is your permanent spousal support. Post-separation support is your temporary spousal support. Having said all of that, it's important to note that practically, once post-separation support has been determined, the court can look at what was heard in the post-separation support hearing. They can look at what they've already determined, and they may determine that that's the appropriate amount for alimony too. So it is important to get it right the first time during the post-separation support hearing.